What's up, guys? Thanks for joining me. Can you guys hear me? Give me some thumbs up, some hearts if you can. Hey, Daylene, great to see you this week. Great to see you this week. And finally meet. All right, guys. So we're going to talk just briefly, reiteration of the same stuff we've been talking about. I just, one thing is I heard earlier this week someone say that oh, he is fighting for the family, and I just kind of want to say that that's what I've been doing all along here, you guys. And whether you can see it or not yet, you guys will soon. All right, because this has always been about the family. I mean, and I keep on saying that to you guys. I've been saying that for years now. We're using the indictment by a grand jury issue for a very specific purpose, a very specific reason, okay? The indictment by the grand jury is what is called an enumerated constitutional right. It's enumerated because it's written in the Bill of Rights. It's written in the Constitution. You can see it right there. It says no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. That's enumerated within the first 10 amendments. The Bill of Rights is the first 10 amendments, guys. That's what it is, the first 10 amendments. So there's a difference between an enumerated constitutional right and an incorporated constitutional right. The right to intimate association, the right to have a relationship with your family without governmental interference, that was found to exist by the Supreme Court in 1986, protected under the First Amendment. That is an incorporated constitutional right. It's not an enumerated. And there's a difference between these two, significant difference when it comes to fighting for these rights. You see, we're not going to go into the validity of the 14th Amendment, but I will say once again that I don't care whether it's valid or not. We're going to win either way, okay? We're going to win either way. And guys, please share this video. We have 8 people on. We should have a lot higher numbers than that. You guys know that as well as I do. The reason why this isn't happening yet, the reason why we're not moving it is because I don't have the backing that I need to be able to get this information out. We need these numbers a lot higher than they are right now. You guys all know this. We got to get these numbers up. So please share, please like, please continue to put this out on the page. If you tap, that's going to continue to put it out on the For Your page until they decide to restrict this account, this video once again, which they seem to have a tendency to do. But there's a difference between an enumerated constitutional right and a incorporated constitutional right. Now, again, I'm not gonna argue the validity of the 14th Amendment. We'll win either way. The reason why is because if they say that the 14th Amendment isn't valid, right, because it was never properly ratified, that's cool. That's fine, because the 14th Amendment was ratified or allegedly ratified in 1868. 1868. The case that we're dealing with is from 1887, Hurtado versus California. 1887 is obviously after 1868, and Chief Justice Waite and his court used the 14th Amendment, the first provision within it, in order to make that decision. Therefore, if the 14th Amendment is invalid because it wasn't properly ratified, that means Hurtado versus California is gone because they relied upon it to make that decision. Which, if the Hurtado versus California is gone, then we're once again back to an unlitigated issue because the Supreme Court has never made this decision because they made it in 1887 after the 14th Amendment was allegedly ratified, and so we win that way. But if we win under the validity of the 14th Amendment, we will under the Privileges and Immunities Clause all day long. The reason why is because The 14th Amendment says, it says, no state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens, okay? Now, what are the privileges and immunities of United States citizens? To understand that, you have to go to two places, okay? First off, there's two different privileges and immunities clauses within the Constitution. One is within the body of the Constitution under Article 4, okay? Now, Article 4 doesn't say what those are because Article 4, of course, is the duties and responsibilities of government. I keep telling you guys, Articles 1 through 7 have no rights within them. Those are duties, those are obligations of government. So Article 4 can't say what those rights are because if they did, then that would mean that the rights and the duties came at the same time. That's not true. So what Article 4 says, it says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. What this particular provision in the main body of the Constitution did is it formulated the concept of egalitarianism, which is the belief that all men are equal. Well, in order for all men to be equal, government and laws must treat them equally. That is an egalitarianism form of government, which means that if you have a privilege or an immunity in one state, you can't be denied that privilege or immunity in another state because that would mean that the laws are applying unequally amongst like members of our society. You can't have that, not an egalitarianism form of government. You see, these states have got it all wrong, and we're going to beat them pretty handily. But, let's just use an example. Let's come up with one. Right now, today, you can go to the state of Oregon, and the state of Oregon has said, we are not going to prosecute for drug possession. You can possess any drugs whatsoever that you want, your heart content, right? And I'm not advocating for this to be good, but I'm saying this is an example of how you guys can fight back, right? If the state of Oregon has created a law that says, oh, yes, you can have the possession of drugs, right, in a certain quantity, possession level, right, for your own personal use, then that is an immunity that the state has created, an immunity from prosecution. It's not a privilege because you don't have the privilege of being able to have drugs, right? Because the federal government still has, the drug enforcement laws. So you don't have a privilege to have it, but they're not going to prosecute you for it. That is an immunity, all right? An immunity. So if Oregon says, well, we have a law and we're not going to prosecute, then you guys, how the egalitarianism form of government works, how Article 4 works is no one within the country can be prosecuted for drug possession, right? Because the citizens in one state are entitled to an immunity, therefore the citizens in all states must be entitled to the exact same immunity. Pretty simple, right? Okay. So, but this hasn't been challenged yet. I'm not saying that this is, don't go out buying whatever it is that you're buying because we don't yet have this particular challenge in place, but that's just an example. Now, this also came from a case called Oglethorpe versus Hodges, right? United States Supreme Court. This was sometime around 2010. And what happened there was that this gay couple, they went up to New York. They lived in New York. They got married. New York said it was completely lawful to be married as a gay couple. And as a result, they were married lawfully by the state of New York. But then they moved to Ohio. And Ohio said, oh, no, we don't have gay marriage here. It's not valid. Therefore, we don't recognize your marriage from New York. And guys, under the FF&C, the full faith and credit clause, the state of Ohio can't say we're not going to accept, what happened in the state of New York. And they challenged it at the Supreme Court. They won. It was there. So, it doesn't, Daniel, but it will in order to get heard. You're right. So what Daniel said over here on Facebook is he says it takes a few more states, citizens of the several states before we reach that point. It doesn't under the Constitution. One state is sufficient to be able to make it apply. But you're right. In order to make this work, the Supreme Court of the United States is going to have to make a decision that's going to correct it. Now, the problem with the Supreme Court is that they don't want to make decisions because they claim this whole states' rights, this abstinence or this abstain policy that they have. They say, we don't get involved in state issues. Bullshit. Right? But nonetheless, this is what they do, right? This is what they do. So So the Supreme Court says that we abstained, and like in the case of Brown versus Board of Education, when they were challenging Plessy versus Ferguson and segregation in the South, that was Brown versus Board of Education of Topeka, Kansas. They only had one state, right? NAACP came up. They were challenging one single state, and they weren't getting anywhere, right? They weren't getting any traction. It wasn't until they enjoined two more states in the litigation that they won. Now, I'm going to tell you guys that right now today, we have 42 states enjoined, right? We have 41 states enjoined. Today, we're going to have 42. And so I'll come back to your statement there. Lawyers are part of the problem. Lawyers are the problem, not part of the problem. They are the problem. But we got 41 states enjoined as of this moment, right? 41 states that we can show are acting in a very specific manner to deprive people of the United States the very rights that are guaranteed to them as fundamental by the United States of America, the Constitution of the United States. That's a big fucking deal, right? But again, what I'm doing is I'm creating a single procedural situation that applies to a massive number of people so we can make this be heard, right? So we've got to be heard. Right now, the court is ignoring me. You all know that. They can clearly hear what I'm saying, right? They know what I'm saying. In fact, I've got a Secret Service and an FBI dossier on me. They're watching everything I do. Great, awesome. If they're watching what I do, they're watching these videos too. And if they're watching these videos, then they know the argument that we have. They know the validity of it. They know how powerful it is, and they know that they're gonna fucking lose. They're gonna lose all day long, which is why they are ignoring me, okay? Great, ignore me. They can ignore me all they want, but that doesn't mean that we're not going to be heard, right? Because once again, you can't go around the country and serve 41 state attorney generals, 41 state Supreme Courts with actual criminal affidavits that are 100% valid, right? 100% real and true of actual victims of per se crimes, meaning that these government agents had a duty constitutionally codified. They didn't do it, right? They didn't do it. There's no denying that they didn't do it, which is why they're silent on this issue. Why are they going to engage me in a debate in which they know they're going to lose? They're going to lose. They're going to lose all day long on this, right? They know that, right? But that's why that's why they don't want to be heard, right? They don't want us to they don't want to hear us, because the moment that they acknowledge that they've heard us, they have to hear the case, and then they would have to make the right decision. They're going to hear us, you guys. This case will be heard, but this is a matter of getting the information out. I need all of you to, When we look at the issue, right? A lot of you say that this is too big. This will never work because it's so big, and that's not true. The size actually is indicative of us being able to win. Size is extremely important, right? Because, and I've been saying this as well, that behind me, right, the argument that I have is that a state cannot be both accuser and judge. They can't. That's codified in Article 3. It's written in the Constitution, never been changed. A judge may not be a judge in a case in which his own body of men that he works with is the accuser. In all cases in which a state shall be party to the Supreme Court shall have original jurisdiction. Original jurisdiction means that is the court to act first. No other court in the country can act before the court that has original jurisdiction. And if a state is a party in the cause, then that state cannot be judging the cause. It's a simple concept. Very, very simple. If I'm being sued by ABC attorneys, I walk in that courtroom, and that judge realizes that he works for ABC attorneys, the first thing that he must do is that he must recuse himself, because he has a conflict of interest. He works for the plaintiff, you guys. Works for the plaintiff. Same thing here. When that judge walks in the courtroom, he realizes that he works for the state of Washington, right? The first thing he must do is he must recuse himself, because the state of Washington is the plaintiff. He has a conflict of interest. He works for the plaintiff. Simple concept. So, but the thing is that there are 2.9 million people currently in prison here across America today. Every single one of them have been charged with a crime by a court that did not have jurisdiction to be able to oversee that particular dispute. And that includes the federal side as well, you guys. It includes the federal side. The reason why is because if the states make the laws and bring the accusation, the federal court must be the judge. That's why in all cases which a state shall be party, Supreme Court shall have original jurisdiction. That's why Alexander Hamilton wrote in the Federalist number 80 that the federal judicial authority must extend to all cases between a state and the citizens thereof. If there's a dispute between a state and the citizens within that, then guess what? The federal judicial authority must extend. The federal courts must be the judge if the state brings the accusation. But what about if the federal court or the federal laws are brought against you in an accusation? Well, according to Article 3, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state wherein which the crime is said to have been committed. Because if the federal government brings an accusation against you, that federal judge has no authority to oversee that dispute, because Article 3 says that the state must be the judge. The way that our system was designed to work, right? The way it was designed to work was that the United States of America made the laws. That's why Clause 1, Article 1 of the Constitution says all legislative power shall be vested in a Congress of the United States consisting of a Senate and a House of Representatives. All laws, all legislative power was vested in the central government, man. Right? Central government. They were to make all the laws, and then they would federate them out to all the regional governments for application and administration. That's what a federal justice or federal system is a federation where the central government creates the laws together so that all laws are equal, so that all men are equal, so that the laws apply equally to all persons across the entire nation. That's the way it was designed to be used, right? The central government was represented by all of the regional governments. They came together, equal representation. They make the laws, and then they federate them out to all the regional governments for application administration. That's what it was supposed to be. Therefore, your accuser was supposed to be the United States of America, and that way the judge, who represents a different government, can be neutral and unbiased because he's not profiting off of the involuntary servitude of the person being enslaved by the accusation. You have to have a separation of powers. You have to have a limited government. And right now today we've got unlimited government because the state seems to think that they can create the laws, that they can investigate those laws, so that they can accuse you of breaking those laws, so that they can judge whether or not you disobeyed the laws, and then so that they can profit off of your involuntary servitude in a for-profit state-run industry for the direct benefit of the state. There's no limited government in that. Same thing with the federal government. You got the federal government who creates the laws, who investigates whether or not you broke the laws, who charges you with a crime for having broken those laws, who judges whether or not you broke those laws, and then who profits off of your involuntary servitude in a for-profit business for the direct benefit of the federal government. No neutral, unbiased decision makers involved in this process, and especially when they remove the indictment by a grand jury. Are you serious? The purpose of the grand jury is to protect the accused from hasty or malicious charges from an overzealous prosecutor. Guys, that's the purpose of the grand jury. Look it up. The purpose is to protect you from a prosecutor. And yet the prosecutor is abusing their power by denying you, the opposing party, the right to be present to confront the accusations against you in a proceeding that's there to protect you from the prosecutor. Are you fucking serious? It doesn't take a rocket scientist to understand that this is wrong, right? That this is unconstitutional, that this is an abusive process, it's abuse of discretion, and it is producing a void outcome because that prosecutor commits a crime every time he denies you your right to be present to confront those hearsay accusations against you. You were supposed to be present because that is a proceeding that's there for your protection, right? As the accused. And anytime the government commits a crime in the pursuance of an outcome, that outcome is always going to be unlawful, unconstitutional, because it derives from a criminal act. You can never have a criminal act produce a lawful outcome. You can never have an unconstitutional act produce a constitutional outcome. If you break the law of government in the pursuance of an outcome, that outcome is going to be unlawful because it derives from an unlawful act. There's no denying this, guys. None whatsoever. So what you guys need to understand here is that you were supposed to be present. to confront those accusations against you in that grand jury, you were always supposed to be present. In fact, we even have a case from 1887 that might be a year that you guys are keying in on, because in 1887 the Supreme Court of the United States decided that the state of California didn't have to do an indictment, that they could charge by way of information, and thus they sided with the state of California's Constitution, not the United States Constitution. But that's an interesting year for me to say that same year we have a ruling from the United States Supreme Court that tells us exactly how a grand jury is to be ran. That case is called Hurtado versus California. The very case that said that we don't get an indictment by grand jury is the very case that you guys can use to say, no, you know what? I was supposed to be present, and you committed a crime when you didn't permit me to be present by not informing me of the proceeding and proceeding without me. That is a fact. Because in the case Hurtado versus California, if you guys go out and read it, go out and read it. Right? In the case Hurtado versus California, what they say, they describe the grand jury process within it. And again, this is the United States Supreme Court. This is the very case that says we don't get an indictment by grand jury. In it, they describe the process, and in it, what they say is they say that the accused is present, has the right to counsel, and can call and cross-examine witnesses. Why is it that in Hurtado versus California, they say that you are present in that grand jury, you have the right to have counsel with you, and you have the right to call and cross-examine witnesses? Because you're always supposed to be present in that grand jury. The state can't deny you your right to be present to benefit from the very proceeding that exists for your protection from the prosecutor. Guys, we have a pretty major issue going on right now. I don't have the proof of it quite yet, but we're getting close, right? None of these indictments are valid. Every single one of them are illegal. Every single one of them are illegal, right? Because did you know that none of the grand jury foremen are signing these indictments? Every single indictment is signed by the prosecutor. The prosecutor. So your opposition, right? The accuser's counsel is the one signing the indictment. They're the one that's presenting the hearsay evidence. Evidence is not even admissible in a petit jury in order to secure whatever charges that they want. They're the one that's denying you being present. They're the one that's refusing to give you the transcripts. And they're also violating the rules of civil procedure by not having the grand jury foreman sign these indictments, and they're signing themselves. It seems to me like the executive branch has taken over a proceeding that was our proceeding, that we never delegated the authority to the executive branch. And now the prosecutor is the one signing every indictment. They're the one that's approving whether or not a crime has been committed, an act and function that was not delegated to government, that was reserved to the people, because the grand jury was supposed to be a neutral and biased proceeding ran by the people that had no control by the judicial branch or the executive branch. The rules of civil procedure say that the grand jury foreman must sign those indictments, and yet guess what? None of them are being signed by a grand jury foreman. How many of you were given a copy of your transcripts for your grand jury proceeding? None, right? None. So let me ask you another question then. How can you prepare a robust legal argument if you don't know what the accusations are against you? Why is it that you don't have those transcripts at a minimum, right? I mean, you're supposed to be present, but how can you prepare a robust legal argument against criminal accusations when you don't know what those criminal accusations are because you've never been given the transcripts? In fact, we're being told across the board that transcripts will not be released without a judge order, if they even get released. And I guarantee you that 90% of you don't have a grand jury transcript at all. And the reason why is because they're not running them, you guys. They're not running them. Think about how many indictments a grand jury could issue in one day if they heard the accusations, legitimately heard them. They heard the evidence against you. How many of them could they run a day? And yet look at the numbers that are being passed through every single day in these states. We have some of these precincts, some of these larger justice systems, these bigger sheriff departments. I mean, they're doing 3,000 a month, right? There's no way that a grand jury could be passing 3,000 a month through. So those aren't indictments. Those are information signed by the prosecutor that they simply titled indictment. They're not grand jury. They're information, because the prosecutor signed them. Because there is no grand jury. They're not running them, you guys. That's what we're finding. That's the evidence that we're coming across now. They're not doing it. And if they're not doing it, well, they're kind of fucked then. They're kind of fucked. So going back, circling back to where we were right now, right? No, we're not calling for an armed revolution. Absolutely not. This is a peaceful assembly to petition the government for redress of grievances. We are not asking for or calling for any violence whatsoever. Please don't make those statements. Those statements will get people into trouble, get people killed or hurt or unalived. We don't want that, you guys. That's not what we want, okay? We are peaceably assembling to petition the government for redress of grievances. We are following our constitutional rights and authority that we have. If something else is necessary to happen, we will do it consistent with what the law permits, and we will do it within our lawful authority, whatever that might be, okay? So please don't make those statements anymore. I don't want to have to block you off this, brother. Please don't do that. Guys, so when Plessy versus Ferguson was being reversed, Brown versus Board of Education, one of the things that happened there was that during that period of time, Dr. King, he was going into a lot of union meetings, right? Down in the South, Birmingham and stuff. And he would go into these meetings, and the rest of the union members would go into these meetings. And one of the things that they did was they sent state police into these meetings to make statements, statements that would incite violence, statements that could be perceived as threatening, as illegal. And they would do this because they were trying to shut down this movement, the civil rights movement. And they would routinely go in and they would do these things. We don't want that here. We have to be very, very careful about the things that are said on these lives, in these spaces, in these conversations, because there are eyes that are watching these, and they're waiting for us to make statements that would be construed or could be construed as dangerous, as threatening, as a terrorist. We don't want any of that. We need to make sure that we clarify on all these that this is an act of peaceful assembly. We are acting within our lawful authority to be able to do that. So let's make sure to keep the statements lawful. All right. So again, going back to the beginning, this is always about the family, because there's a difference between an enumerated right and an unenumerated right. So going back to the 14th Amendment. 14th Amendment, and again, I'm not arguing the validity of it. We're going to win either way. But the 14th Amendment says that no state shall enact or enforce any law that shall abridge the privileges and immunities of United States citizens. We already went through Article 4 creates certain privileges and immunities that exist. Article 4 does, right? To understand what those rights and privileges and immunities are, you got to go to a case called Corrywell versus Washington. This is General Washington's or President Washington's grandson, okay? And it will tell you what is protected by Article 4. If you guys want to know, Corrywell versus Washington. Corwell versus Washington. Look it up if you guys want to know Article 4. But if you want to know what the 14th Amendment protects us against, well, you can go to a case called Timbs versus Indiana. That's TIMBS versus Indiana. 2019, unanimous decision. 6 of the same justices that we have on the court today made this decision. And what they said, go read it. What they said is that the privileges and immunities of United States citizens are, at a minimum, those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. So if it is enumerated within the first 10 amendments to the Bill of Rights, then that is at a minimum, what you're guaranteed under the 14th Amendment's Privileges and Immunities Clause, right? But it must be enumerated, because that's what the court said, enumerated. So it has to be written there. Guys, I've been telling you for a while here that every single one of the 14th Amendment's provisions have all been incorporated except for one. There is one left to be incorporated, and that is called the Grand Jury Clause of the Fifth Amendment. This is the last provision to be incorporated until we go back to 1833 and say, Supreme Court of the United States, Chief Justice Marshall, you committed sedition, right? You're a traitor. Your court's a traitor because you amended the Constitution other than lawful manner when you told all the courts within your purview that they don't have to obey the Constitution of the United States, that they don't have to give the people their rights that are guaranteed to them under the Bill of Rights. That is Barron versus Baltimore. You guys go read it. That case will tell you exactly that. That's the reason why you don't get indictment today, is because in 1833, the highest court in the land made a decision directed to all the courts within the nation that you don't have to give the people the rights that are guaranteed under the Bill of Rights. Not true, but nonetheless, we have incorporated, because that's the incorporation doctrine, is when the Supreme Court hears and incorporates those provisions. There's one left to be incorporated. Every other one has been incorporated already. The last one to be incorporated is the Grand Jury Clause. But you guys, this is the hardest one of all. The hardest one of all, because this is the one that's going to set the people free. Because this is the one that they didn't want anyone to know about. They didn't want anyone to understand. They didn't want to have to admit, because this is the one that's going to set the people free. Set the people free. You're right. That is the reason why the Second Amendment exists. And even Thomas Jefferson said it. We just got to say it in such a way that they understand that we're acting within lawful authority, whatever we might do. I wouldn't call for any sort of violent acts or violence at all, because you guys, a patriot is defined as one who loves and defends his country. One who loves and defends his country. That's a patriot. So patriotism is a dialogue between your fellow man and larger world as a whole about not only what is good about your country, but how it can be better, right? See, patriotism is rooted in humanity. It brings peace and harmony. Nationalism, however, is an arrogance. It's a pride about your country, about how great we are and amazing we are, without having any introspection about, the issues that we might have. But you see, domestic policy that's in conflict with foreign policy is rendered ineffective, and we are rightfully labeled hypocrites. So we're rightfully labeled hypocrites. So before we can go to another country and demand that they set their people free, we must first ensure that what we are practicing here at home is consistent with what we preach overseas and abroad. And it's not, right? When we go to Iraq and say, set your people free, and yet we here in America, we imprison and enslave our people at a rate of 16 times more than the next closest industrialized nation. Don't think that they don't know this, right? Don't think that they aren't calling us the hypocrites that we clearly are, right? So we got to address the domestic policy and not just simply go out overseas and preach foreign policy that's inconsistent with what we practice here at home. So a patriot is one who loves and defends his country. Patriotism is a dialogue. It's communication. It's talking, right? It's a debate between your fellow men. It's not let's go out and get arms. Let's go out and get guns. Let's start shooting each other. Let's destroy our country. Because if you love something, you guys, destruction would never be an optional outcome for that's loved. I don't want to see the destruction of my country. I'm going to fight with my words until the day that God takes them away from me and doesn't, because that's the least destructive thing that we can do for this country. Those people, the Supreme Court, guys, they're ignorant. That's the reason why they're doing things they're doing, is because they're ignorant. Not because they want to destroy the country, but because they don't realize how destructive their actions actually are, you guys. That's a fact. Trust me, right? They don't know what they're doing. They've been led astray. Mr. Thomas You know, you might say that you're an honorable man. You might say that you went to Harvard because you want to set your people free. But I'm going to tell you, man, your actions are pretty inconsistent with such a statement because you're actually kind of a piece of shit, Mr. Thomas. You're kind of a greedy, fucking worthless because you're out here and you're taking these bribes and all this other stuff. But you know what? At the end of the day, we understand that money poisoned you as much as it poisoned me and my family and, you know, millions of other people that the money poisons as well. But it's never too late to do the right thing. It's never too late, Mr. Thomas. You can always step up and do the right thing because guess what, man? You know, you can come back from your apostasy. You can come back from your greed and your ignorance, and you can do the right thing because it only takes one justice to sign the writ that I delivered to you on September 29, 2023 under the case Tanoa M. Downing versus State of Washington. It only takes one justice to sign that. You could sign that. And you could return to, you know, an honorable state. You could restore your honor by doing the honorable thing, by taking honorable actions, by actually, you know, directing all of your agents to act in an honorable manner because you're going to lead them in the direction of honor, right? That's something that you can do. But these justices, you guys, they don't realize what they're doing, right? Take for instance, all these attorneys, right? So was I just bullying? I don't know. I don't know if I was just bullying. Maybe it's something in here. I don't know. I don't think that was bullying personally, but maybe whatever. I apologize if I was bullying anybody, Mr. Thomas. I'm sorry if you were offended by this or any one of the other plants that might be on here. You know, now trying to flag me because I'm talking shit about your leader. That's despicable, but that's cool. But these attorneys, guys, you see, the problem with the attorneys is this. Every single thing that they've been taught is a lie. It's bullshit. Every bit of it, right? Because these attorneys are administrative officers of the court. Look at the corpus secundum, right? The attorney handbook. It says that an attorney is an administrative officer of the court. What is an administrative officer? Well, first off, you got to understand what administrative law is to understand what an administrative officer is. Administrative law is there are three branches of government. All law is made by the first branch of government, right? All legislative power is vested in Congress of the United States, consists of the Senate and House of Representatives, Clause 1, Article 1. So anything that has to do with law comes from the people, legislative branch, period. I'm not going to talk about statutes. I'm simply saying this is the structure of our system of government. Right? So everything to do with laws, making it, amending it, destroying it, all vested in the first branch of government, the legislative branch. The second branch of government is known as the executive branch, and they are there to enforce the laws. They enforce the laws as written by the legislative branch. They have no authority to create laws. They create orders, executive orders, but orders can only affect those that are being ordered, right? So only people within the executive branch follow orders. Because the president can't order you because he's a servant to you, right? So orders are directed to those that can be ordered. Executive orders only affect the executive branch, guys, no one else, right? Because he can only order those that can be ordered, his people, his agents. He cannot create law, which is why in Chevron this last year, June 28th, the Supreme Court came out and said, executive branch, no, you don't get to say that a law is ambiguous and then write policy and go out and enforce that policy as though it's law, because that would be amending the existing law by a branch of government that has no authority to amend the law. Right? That's what Chevron was about. So, no, executive branch, you have no legislative authority because all legislative power is vested in Congress of the United States. Now, the third branch of government is known as the judicial branch. They are there to administer the law because they are the administrative branch. They are there to administer law, but they don't create law either. They create rulings, right? And rulings only affect those that can be ruled, which are attorneys. Because when the administrative branch creates a ruling and then erroneously and unconstitutionally calls it law, case law, and then they direct everyone to follow their case law, well, an administrative officer of the court would follow administrative law. That's why attorneys follow case law, right? That's why they tell you, oh, yes, that judge, what he says is fucking the truth because he's the judge. No, he's not. He's a fucking piece of shit traitor. That's what he is. What he speaks isn't the truth, it's a lie. But that's what attorneys do. So if you understand that what he speaks isn't the truth, it's a lie. But that's what attorneys do. So if you understand that that's what attorneys are, administrative officers of the court, and they are following the administrative branch, they are trained to follow case law. Here we are, right? So now you can understand why the decisions that they make would be bowing down to this judge, thinking this judge is something important when he's nothing but a criminal, right? They've been trained to do things wrong. Their entire career has been wrong because they were taught to do things wrong, right? But I understand. I mean, I'm trying my best, but I want to be truthful here because it's so important that people understand this. It's so important. So we've got to understand that these attorneys are administrative officers. They follow administrative law. They follow the courts. That everything they've done their entire career is a lie because judges don't create law. That's the heart of our argument, right? That is the heart. So if we want to return the Constitution to its foundation, two things had to happen. The first is we had to remove all the bullshit that the executive branch put into place, all the policy, right? We got that with Chevron, although it's not in place yet, right? It's not being enforced yet because that was something different. But nonetheless, first we had the judicial branch say to the executive branch, you don't get to create law. All that bullshit that you built, it's all got to go away. Yes, it does, right? Because that's the foundation, right? The Constitution isn't the foundation. These rulings and orders and all this other shit from the executive branch, that's what's at the foundation. So that had to be removed first. But the second thing, and what we're working on now, is judicial branch, you don't create law either. Get rid of all your bullshit too. Get rid of all that, right? So we got to get rid of the judicial rulings that was erroneously called law that amended and fundamentally changed the Constitution of the United States, such as Hurtado versus California. Because if Hurtado versus California says, California, you don't have to have an indictment by a grand jury, and yet Clause 1 of Amendment 5 says you must have an indictment by a grand jury, then that means that in 1887, the Supreme Court of the United States amended the Constitution in an other than lawful manner by a branch of government that has no authority to amend the Constitution. The only branch that can amend it would be the people through the legislative branch. Nothing else can change the Constitution but that. So, the hell? What the hell? All right, so we have to remove all of the executive orders. That's not law. That doesn't affect the people. Get the fuck out of here. Gone. Then we got to remove all the judge-made rulings. That doesn't affect people either because that's not law either. Get rid of it. Get the fuck out of here, right? Once we do that, then what happens is the Constitution falls back to its foundation. We find our law back where it's supposed to be, and now we can live a life that's predictable, that's based upon a formal set of rules and principles. We find ourselves in a world consistent with what it is that we believe in. But we got to get this judicial branch to acknowledge the fact that you assholes don't make law. You make rulings. Those rulings better be consistent with what the people say that they must, because you don't create law here in America. You have no delegated authority to do so. And if you do want to make law, then awesome, you're a traitor, and we're going to make sure that you're held accountable for your treason in whatever way we are lawfully able to do so. Right? So this is what we're trying to do. We're trying to put that Constitution back to foundation. But going back to the very beginning, where I started all this, and I got to get ready to go because I only have a few minutes before I have to check out and have to get going on down the road. But here's the thing, you guys. Here's the thing. The whole point is to get the Constitution back to foundation. How do we get it there? We have to do it through an enumerated constitutional right. We have to find a right that is specifically enumerated within the Bill of Rights that these states are depriving us of, and that is why I'm using the indictment by a grand jury. Guys, those people that are in prison, those people are someone's children, right? They're someone's child who over time was caught up in this system as a child through CPS or through a number of other things. There was trauma was created because, remember guys, today right now there are 12 million children in the CPS system. That's 12 million children who are getting trauma inflicted upon them by an institution that has no authority whatsoever to be able to remove them from their families, and yet they have. These are children. These are children that may never, ever, ever be healed from the trauma that's been inflicted upon them. May never be able to. And as a result, they grew up into adults that have an 80% likelihood of going to prison themselves. This is a system that is building a self-sustaining product through your children, right? And through your trauma, by destroying your family, your marriage, so that you will be hurting, so that you will feed into their system. This is a fact, you guys. And so anybody that says to me that these prisoners don't deserve to be fought for, that these prisoners deserve to be in prison, I'm going to say to you, go back and start reading some Bible, okay? Go back and get to know God a little bit better, because that's not how shit works, right? Your forgiveness doesn't derive from their acts, right? You gotta forgive to be forgiven. It's real clear about this, right? Those people that are in prison were once a child that had something horrible and tragic happen to them, and no one gave a shit about what happened to them, right? Then they grew up into an adult that did something that was not within the parameters of our society, and then we said, look at what that monster fucking did. And now we're going to lock that monster up. We're going to send him off to this place because he's a monster. But that monster was created by this fucking system. That monster was created by the Supreme Court of the United States coming out and saying, oh, sexual deviance is okay. Porn is completely lawful. It's legal. We're going to flood every single household with it. And in doing so, we're going to say sexual deviance is promoted, right? And then when these brothers and sisters go and act out in something because they're already predisposed to it, right? We're going to say, look at that monster. I'm going to say, no, don't look at the monster, guys. Look at what our government did to create that fucking monster. And what can we do to make it so that that monster doesn't exist anymore? So this is about the family. This is about the children. But I have to use an enumerated right. I can't do it any other way, you guys. You can't do it any other way. If you want to come forward with a CPS case and you want to argue a CPS case under Roberts versus United States, good luck, because that is incorporated. It's not enumerated. You will not get anywhere with an incorporated right and not an enumerated right. I'm doing this because this is the direct avenue to get your fucking children back home, to restore your family, to deal with these monsters by removing the monsters and healing them from the trauma that's been inflicted upon them by an institution that had no authority whatsoever to be able to do the things it's done, okay? This is the path forward. We must find an enumerated right, and we found that with the grand jury. We found that in the grand jury, and even though those are prisoners that it appears to be that it appears I'm fighting for, guys, I'm fighting for your family every single day. That's what I'm doing. I'm out here. I'm fighting for you, and I'm fighting for your family. All right, I got to get going, but a few things here. I want to bring up one more thing. And you guys, if you guys are offended by the things I'm about to say, I'm sorry, right? I understand that we have a politically charged society right now that everybody's really so I'm sorry if you guys are offended by the things I'm going to say, but I'm going to say them anyway. I'm going to say them because I need you guys to be thinking about something. I need you guys to think about it, okay? Remember what I used to do. Words and actions. Words and actions. I'll answer your question one moment, Trace. So words and actions must align, okay? If they don't align, then you're a liar, okay? Words and actions must align. What I used to do, right? I was in the military, special operations, got out, went to work for intelligence, went to work for Homeland Security, went to work for Department of Energy. I'm a human lie detector. I know liars. That's what I do, okay? So this is the thing, okay? So you guys are reading this DOJ memo, right? And you guys are like, oh my God, this is the answer. What he wrote to Grassley. All these judges are unconstitutional. That's awesome, you guys. That's awesome. But words and actions, okay? Words and actions. Because the words say that these judges are unconstitutional, that they work for the executive officer, and yet today, the executive officer still has his prosecutors in courtrooms all across the country prosecuting by information and prosecuting people who have been unconstitutionally arrested. Those words and actions do not align, you guys. They don't align, okay? If you believe that they're unconstitutional as a judge, then why are you continuing to work with them? Because if you work with unconstitutional judges, what you're producing is unconstitutional. And yet today, prosecutors all across the country are continuing to prosecute by information people then illegally and unconstitutionally arrested, right? So here's the problem. I want you guys to understand what is going on. I want you guys to understand. I want you guys to understand the truth here, because this is very important right now. Very important. Last year, right, what I did was I went through starting in May and ending on June 6th. I served 32 state Supreme Courts, or 32 state attorney generals. And I served them with notices that their agents, the prosecutors, are committing unconstitutional acts or illegal acts. They're committing crimes when they charge people by information, not by indictment, in contrary to constitutional demands that they have, obligations they have. So I went through and I served all of them. The last service that I did was in the state of New York on behalf of Donald J. Trump. I served on his behalf. I served the Attorney General of the state of New York. You guys can see the video. It's done. Right? I served on his behalf because, you guys, he wasn't present in that grand jury to confront the accusations against him. He wasn't, right? Regardless of whether I like him or don't like him, that's irrelevant. But what happened to him was unconstitutional. It was illegal. It was a crime because he was not permitted to be present in the proceeding that was there for his protection. Okay? That's a crime. It's called conspiracy to obstruct justice. So there's the first issue, right? I went and I served on his behalf. What a lot of people don't know is the very next day, I served the state of Delaware on behalf of Hunter Biden, right? Now, why would I be in New York serving on behalf of Donald Trump and then the next day in Delaware serving on behalf of Hunter Biden, right? Those seem like two completely different things, don't they? Yeah, I don't like Hunter Biden. I don't like, but you know what? He wasn't present in that grand jury either to confront the accusations against him either. What happened to him was also a crime, right? But I needed to get attention from both of these heads of state, right? I need to do anything I could to get their attention. So yeah, I'm going to go into Delaware while Hunter Biden is in the middle of a trial, and I'm going to serve the Attorney General on his behalf saying, this is a crime, what's happened to him, stop the proceeding, don't go any further. That's what I did, right? I didn't like doing it. In fact, even in the video that you guys see, I'm like, I don't agree with this, but I can't control what God is asking me to do. I'm going to go do it. So I finished then. The next day I was in D.C. And at this point in time, then what I did was I went around and I started serving all the state senators through their agents. Started going through and started serving all the state senators and the congressmen. So now I was bringing them in. And I didn't really realize why God was doing this, because I knew that Chevron was being argued, but I didn't really know the ramifications of Chevron. So that was on June 7th. I'm back in D.C. Between June 7th and June 28th, which is when Chevron was ruled on, between that period of time, I was out serving all the United States senators and all the United States congressmen, providing them notice as well. Then what happened was Chevron came out, the ruling. And everybody was so excited about Chevron. They're like, oh my God, this is the answer. Everything's fixed and we're going to have a just system. And did we get a just system from that, you guys? Or was that just glazing, right? Was that just a bunch of talk? Right? You all said yourself, oh my God, this is the answer. They're gone, right? And it wasn't the answer, was it? Right? They're not doing the things that they say that they were going to do. They're still out enforcing policy right now, aren't they? So it wasn't the answer. But you guys thought it was, because it was a diversion. Because what Chevron was about, it had nothing to do with right or wrong. It had to do with the fact that the Supreme Court of the United States knows now that they're going to have to address this indictment issue. This is a big deal, and they know it's coming down. They know they're not going to get out of it. They know that the cat is out of the bag. There's enough people that know about this shit that it's going to have to be addressed. Even if they take me out and make a martyr of me, they still have millions of people now that know about this issue. Someone's going to win this case. Someone. And they know that shit, right? They know it. So Chevron was all about them pointing at the executive branch and saying, executive branch, your prosecutors are bringing to me the incorrect charge and instrument. Your prosecutors are bringing information, not indictment. My judges are complicit in it because yes, they are agreeing to hold someone over, but they're not the ones making the mistake. Prosecutors, you guys are. So Chevron was all about the judicial branch saying to the executive branch, we're no longer going to participate in this criminal conspiracy. You don't make law. You don't get to say it's ambiguous whether or not you have to have an indictment or not, and therefore write policy that say that you can use information and thus bring information to us, right? You don't get to amend the Constitution. That's what Chevron was about. That was the judicial branch pointing the finger back at the executive branch and saying, we're setting you guys up for the fall now. You guys are going to take this, right? Gorsuch should be doing it, but I'm hitting Gorsuch really hard because Gorsuch isn't doing it, right? Gorsuch is talking about it, but he ain't fixing it, which means that once again, words and actions don't align. Gorsuch, you're a fucking liar, man. You're a liar because your words and your actions are inconsistent with one another, and I'm gonna call you out for the bullshit that you're doing, right? You can write in your book about how honorable you are, system, but you know what? You lead all these judges. You're their leader, and yet you're refusing to lead them in a lawful direction because you're a criminal and you're leading them toward criminality. So we're gonna be honest about that, but okay, so once again, you go back to the Chevron ruling. Chevron was an affirmative action from one branch of government notifying the other branch of government that we are no longer going to participate in your criminal acts. That's what that was about. So now you have Chevron that hits. And Chevron was all about executive branch. You don't get to do whatever you want to do, right? But the very next week, you guys, this is what you guys aren't asking. This is what you guys aren't seeing. The very next week, we had the Trump immunity ruling. The very next week. And the Trump immunity ruling said, executive officer, you can do whatever you want. So June 28th, we have the Supreme Court says, executive branch, you cannot do whatever you want. And the very next week, we have the same court, same justices saying, executive officer, you can do whatever you want. Why aren't you asking about those two rulings? Why aren't you asking about that? Because those are in direct conflict with one another. They don't even make sense, right? And at this point, this is when I panicked. I knew at that moment, when that ruling came out, I knew that there was a quid pro quo that existed. I didn't know what it was, but I knew that there's a quid pro quo. And so the Spirit told me, get out of DC, get out of here. And so I jumped on my motorcycle and I blasted out of town, heading south as quickly as I could because I knew that there was something that was up and I didn't know. I didn't know. So I'll tell you how to fix it in one moment, but I want you guys to understand the issue. Please stay with me, you guys. I know that sometimes I'm long-winded, but you guys need to understand what I'm about to say here. You guys need to understand. Got on a bike, my motorcycle, rode down south, and the very next week on June 11th, I was laying on my back, July 11th, I was laying on my back on the interstate right after my front tire on my motorcycle fell off because the forks were cut. I don't care what anybody says, the forks were cut. We can see the clear cut. I'm laying on my back in the middle of the interstate after having gotten into that accident. That was the day before Trump's attempted assassination. They tried to take me out, right? So that happened. I panicked a little bit. That's why, Spirit told me to get out of town. But I knew that there was a quid pro quo that existed. I just didn't know exactly what it was. And let me tell you right now, I know what it is now. I know what it is now. Again, I apologize if I offend some of you on this. I don't know if Trump is doing this intentionally or if he's been compromised. But I'm going to tell you what's going on. That ALJ memo is another diversion. Because our government's the greatest at diversionary tactics. I keep telling you guys, this is what I did for the government. They taught me how to do it, right? They're creating a diversion. And they're making you look over here. Because they're saying to you, all of these judges all work for Trump. They're all hearings officers. They're all part of the executive branch. Because if that's true, and you guys buy into that, you guys accept that narrative, Trump can grant them all immunity. Because he's been given immunity. He can grant all of his agents immunity, and in doing so, everything that they've done is going to be valid. If you guys accept what it is that they're feeding you. If you buy into what it is. So right now today, they're telling you all of these judges all work for Trump. And they've granted Trump immunity. Which means that Trump can grant his agents immunity now. And therein lies the quid pro quo. Why is it that they were prosecuting Hunter Biden at the same time that they were prosecuting Trump last year? Because they wanted to get dirt on both the heads of state. They didn't care who it was, but they wanted to be able to have the leverage that they needed to be able to force whichever one of them to comply. Because they're trying to find a way out of this. They're not trying to find a way through this, right? They're trying to find a way to make it so that they don't get in trouble, so that they don't have to tell the truth, and so they don't have to be held accountable for the crimes they've committed as the judiciary. And they have dirt on Mr. Trump, right? Oh, you've been prosecuted for 40 felonies, right? We'll make those go away. You won't spend a day in prison, but you're gonna have to work with us, right? You're gonna have to help us out here. You're gonna have to protect our judges. We're gonna grant you immunity, all right? And in doing so, you're gonna make sure that our judges are all granted immunity. And this is exactly what's happened right here, okay? But this is how we fight back, right? This is how we fight back, please, okay? This is how we fight back. If I'm walking down the street and I have a water gun in my pocket and I pull out that water gun, I point at you and I say, if you don't give me your money, I'm going to shoot you. You give me your money because you believe that water gun was real. Right? You believe it was real. And therefore you gave me your money not because you wanted me to have your money and not because you were scared of a water gun, but because I portrayed it as a real gun and you interpreted it as a real gun. This is a very, very important concept for you guys to understand right here, okay? So it's up to you to decide whether it was real or not. You're the victim, and the victim gets to decide whether it was real. So if I portray it as a real gun and you believe that it's a real gun, and I'm going to prison. Same thing with these ALJs now. You guys, you walked into a courtroom believing that person had the authority to call you there. They portrayed themselves as a judge. They said that they were a judge. The judicial branch never corrected that they weren't a judge. That means they were a judge. Don't buy into the bullshit that they're a hearings officer, that they work for the executive branch. That was a judge when you walked into that courtroom because they portrayed themselves as a judge and you accepted it, and therefore you entered into a contract based upon something that was under duress by someone that didn't have authority to do it. This is our way out of this. Do not let them shift these people over under the executive branch. Don't permit them to do that. You continue to push and say, bullshit. You told me that you were a judge. You portrayed yourself as a judge. You are part of the judicial branch, and the judicial branch doesn't have immunity. Don't let those judges, don't let these hearings officers get immunity, because if you do, everything that they do is going to be valid. If immunity is granted onto those agents under the executive branch, every single thing that they've done, all the decisions they made, all the children they've robbed, all the people that they've locked up and trafficked are all going to be 100% valid. Don't let that happen. Do not buy into the bullshit and the rhetoric that they're feeding you. Fight back. Look through this with clear vision and clear thinking, and know that anything that our government does is a diversion to get you looking in the wrong direction. Don't do it. When they tell you to look at the executive branch, you keep looking at that fucking judicial branch, because they're the criminals. They're the criminals, all right? I got to get going, guys. It's 11 o'clock. I need to get changed. Okay, so right now, today, we're bringing on the 32nd state right now. Okay, so I'm going to leave here. We're going down to do a 32nd state. Get the 32nd state and joined. Then we got to go south for a couple meetings, all right? And then we're heading back west, all right? I've got to get to Oklahoma City. We got a press conference with a friend of mine who just won a judgment through a jury trial, and the state of Oklahoma is refusing to acknowledge it. She is getting her children back, which was what the jury decided, along with a significant amount of money, and the state of Oklahoma is refusing to do it. So we're going to have a press conference. We're going to have a discussion. We're going to make sure that the state of Oklahoma, Mr. Stitt, Mr. Drummond, you guys know how big of a piece of shit you guys are, and we're going to go ahead and talk about that a little bit. So I'm heading back west, but I have a couple. This chair sucks. I have a couple stops that I got to make along the way. Brotherly Love Podcast, I'm coming your way, brother. All right, we're gonna do a podcast there, and I hope to get up into up a little bit north of Oklahoma for one other podcast that we're gonna do in person with a friend of mine, Ricky, who I just did a podcast with. Guys, there's still a lot of podcasts that are out there available. Power Man, you guys can find it on Spotify. That was, I believe, the most recent. But I also have Toward Anarchy that was just released. I have Awakened that was just released. So we have a whole bunch of new podcasts that are out there. You guys are able to do it, and so that's where we're at. That's where we're going. And I had a great meeting yesterday with some friends up in Rhode Island, Massachusetts, and I think we got the next step here. I think I know what we're doing next, and it's another trip around the country. I'm so tired of doing these trips, but it's what's necessary because we still have a state agent that is not served. I'm not going to clarify any more than just that, but we have one other person now that we need to elevate this to and get that addressed. So thank you guys so much. Please continue to like, follow, share, guys. If you can, we need donations. I mean, I'm doing this because God's empowered me to do it, but I need you guys to support. I can't do any of this without your support. So if you guys can, please donate. We have Cash App, Chime, Venmo, PayPal. They are all exactly the same. It is We Shall Be Free. That's WESHALLBEFREE. We shall be free. Okay, and every single cent counts. Every single cent goes to overcoming this system. There is no orthodontist, kids orthodontist payments. There's no retirement benefits. This is all 100% going to how do we overcome the system. So you guys, please donate if you can. Please get out to the website if you guys haven't already. The affidavits are there. It's available. You guys can download the affidavit and get it filled out. They are still coming in. I was just in New Hampshire just the other day. I picked up a few thousand of them. Awesome, great. And so they are still coming in. Even though some of these post offices are blocking them, even though they're holding them for 3 months, whatever. Keep them coming. And so if you guys don't get through, and it returns to sender, try a different post office box. I can't tell you, any more than just that, but know that they are still getting through. And if they keep on getting returned, you guys can hold them on site because I'm coming back to your state. I got at least one more trip around, probably 2. It sounds like, but we're about to start the next step here after this conversation I had with the guys up in Rhode Island, and I think we got a plan. So once again, we start these tours out of Oklahoma, so it makes sense that I'm coming back to Oklahoma right now for this press conference. Samantha, I'll see you here real soon, guys. All right, thank you guys so much. Please continue to like, follow, share. Please comment if you can. Please donate, guys, and together we shall be free. All right, thank you guys. Have a great rest of your day. Okay.